Now let's listen to Stewart and Keith discuss the options and their recommended approach to this difficult problem.
All right, so Keith, I threw a little bit of a curveball in here because we had as our options to remove the trustee, to get the trustee Ben here to account. Maybe we want to surcharge him. Do we want to file a trust contest, which I thought was a nice little thing to analyze, or do we see if we can get Ben to simply resign? The curveball I threw in was a little bit more of a specialized way of analyzing this, and that is, hey, if Sam is named as a co-trustee under the amendment, let's go to the probate court and get him confirmed as a co-trustee, and that gives us access to information and gives us the ability to go after Ben now. What are your thoughts on that option?
Yeah, it's interesting curveball, and it wasn't something that we had on the options, but the thing that I like about it is so often when we're talking about these cases, what we're talking about is trying to get people's money out of trusts, right? We don't always talk about other types of rights that could be equally as important, and that is being a co-trustee. That's a right. There's power that comes with that. It's a power position. And normally, in most cases, it wouldn't be worth trying to fight to become co-trustee necessarily. But in this case, it very well could be worth it. I mean, this is a large estate. You have somebody who's not getting information. And more important than that, they're not being involved in the decisions. So I think if you go to court and say, hey, this guy is supposed to be involved in the decisions, and by being a co-trustee, he can do that, it's a really interesting opening move. And, a lot of this stuff, you've said before that practicing law is more art than science. I mean, there's no right answer here, but I like the option. I like the idea of trying to get him into the power position. And then once he's there, having access, and now we can go on to some of the other options that we did mention, such as trustee removal, removing the other trustee.
Let me ask you, if you were Ben in this case, and you had attorneys that were filing to have Sam brought on as trustee, and let's just say you had done some things that were inappropriate and wrong, how are you feeling about that petition?
Not good. I mean, I do not want, if I were Ben in Ben's shoes, I do not want Sam to be co-trustee. Because if Ben wanted Sam to be co-trustee, he would have told Sam that you're co-trustee. I mean, why did he hide it from him for so long? Obviously, it's because he didn't want him to act in that position. And I don't know why. Maybe he thought that Sam didn't have the ability to act. Maybe he thinks that he doesn't have the financial means. I don't know what it is. Maybe it's just controlling. But I seriously doubt that Ben likes that development.
Well, and then let's assume that Ben hasn't done anything wrong here, or at least not anything wrong from his standpoint. He feels like he's been a reasonable trustee. We run into these cases where trustees make the trust essentially their employment going forward. And here you've got Ben not only receiving an annual trustee's fee, but he's also getting money to manage the trust assets. So if the trust hangs on to those assets, who is that benefiting? Is that benefiting the ultimate beneficiary, Sam, or is that benefiting the trustee, Ben?
Yeah, I think Ben's getting a lot from it. So this becomes Ben's pension, right? His retirement pension. And it can go on for as long as Ben lets it go on. And the really, I think, despicable part of this particular case is that Ben is kind of abusing Sam in the sense that Sam could be living so much of a better life, and he's not. And that's the part that really gets me about this case.
Okay. And obviously we change facts up in cases that we do on video, but we had a similar case in the past, a few years back, where this hypothetical, we drew from some of the facts there. When I first heard that case, I didn't believe it to be true just because it just blew my mind. But in fact, it was as bad as we assumed. What are some of the things that we learned from that case? What made us better lawyers in representing our clients going forward?
I mean, I think we learned a lot from all of our cases. And not only is this hypothetical representative of a case that we handled, it's representative of probably hundreds of cases that we've handled. There's elements of a lot of different cases in this one particular fact pattern. But the thing that's so interesting about it is, number one, these things happen. I mean, it is hard to believe. Like, how could a trustee like Ben, who's a CPA, how could he take this position and be so unreasonable with the way he's treating Sam? I don't know, but it happens. And the thing that you have to do is you have to take action. So that puts Sam in the responsibility of having to take action. And Sam's powerless. He has no money. He's not getting any distributions. He's not getting access to information. It's not like Ben's going to hire a lawyer for Sam using the trust money. So Sam is truly powerless in this situation. And that's really where I think we can do the most good, is helping people who are being absolutely disrespected and just humiliated. I mean, Sam's a beneficiary of what, $8 million? And he's being treated like this? I mean, that's despicable. And that's really where I think we can do our best work, is being able to help people like that. What lesson did you get from this case?
Well, not all the time do we get to represent people we like. In several of our cases that run down this hypothetical, we've had the pleasure and privilege really of representing some very fine people that we cared about, and we grew to love, may be a strong word, but we thought of them as family members. And we were very upset about the fact that they were being abused and they were being mistreated by this trustee. I mean, here Ben clearly knows that that Sam is a co-trustee of this trust, and he intentionally hides that from him. And clearly, Mom, she wanted Sam to have some guidance, some help in running the assets. That's why she did the amendment, right? She wanted to make sure there was some guidance, but she wanted him involved in that decision making. Mm-hmm. And here you've got Ben, who's using this trust really as his, like you say, pension plan, his retirement. And you've got poor Sam, who's maybe not in the best of health. He doesn't need an apartment building with a bunch of improvements made to it that get paid off over 30 years. He needs a standard of living now, and that's more than $3,000 a month. So what I got out of this was helping people who were in a position where somebody in power, a trustee, was taking advantage of their power, hurting that person, and we were able to help them, our clients, ultimately get rid of that person, get them out of the picture, mm-hmm. and get a good trustee and somebody that cares and wants to do a good job for Sam as his mother intended. And so these are the kind of cases where you walk away from feeling good, like you've done something good for somebody.
So if you could only do one thing in a case like this, let's say that you have your option of either removing Ben as trustee and going for a surcharge against Ben for his damages, or seeking somehow to get a distribution out of this trust, whether it's terminating the trust or getting a large distribution into Sam's hands, what is the top priority in your mind among those choices?
It's tough because the facts and circumstances of each case will dictate where we're going to go on that. Obviously, if we find that Ben is a good human being, a decent person, a moral person that just happened to make some really bad decisions, but not intentionally, well, maybe surcharge isn't going to be all that important. As you know, many judges, if they're going to surcharge somebody, they have to kind of not like them. And if Ben is actually a good person, a decent human being, and he's just made some incorrect decisions based on bad information or lack of studying what his requirements were as trustee, in that kind of a case, we're probably not going to come after surcharge. But we certainly want to say, okay, in that type of a case, Ben, you've made some mistakes here. It wasn't intentional. We want to get a real professional in. We're willing to waive any surcharge we have against you and bring somebody else on. Ben is probably going to take you up on that offer. It removes Ben from the picture, brings in a new fiduciary, a new trustee that knows what they're doing, and they're going to diversify the assets as the probate code requires. They're going to sell the assets, have a pool of cash there that's going to kick off income. Hopefully that income is enough for Sam to live on, but if it isn't, there is that principle that you can come on and take a little bit from time to time to make sure that Sam has a standard of living that his mother intended him to have.
And it seems to me that priority number 1, too, has to be get the money out of Ben's hands. And so if I can accomplish that through removal, then that's what we should do. If we can accomplish that through getting a distribution out of the trust or termination of the trust, then let's do that. Whatever we can do to get the money out of Ben's hands, I think, is priority number 1. So I would agree with you that surcharge is a little bit more dicey, a little bit more difficult, because it depends on the facts. It depends on if the person was just negligent or reckless. It depends on what the trust says. Some trusts actually relieve the trustee of liability. And then you've got the probate code that says the judge can always give the trustee an out if they choose to, which is a little strange, but that's what the probate code says. So surcharge, yes, if you can get it, but priority 1 has to be get the money out of Ben's hands.
I agree with that.